My practice area is the representation of public and private educational institutions ranging from large public school systems to small private schools, colleges and universities. And I also represent private businesses in management-oriented labor relations and employment law. Our education and labor practice group represents many of the education institutions in the state of Maryland, most of the public school systems indeed. And we have been providing direct services to our school system clients and to our private school clients through representation in litigation, in collective bargaining, in providing seminars statewide and national basis. And we truly try to educate our education clients in all of the legal areas that affect the business of education, not only in employment but also in student rights, student activities, procurement, sports related matters. There are many, many facets to running an education institution, and there are legal ramifications for each, and so we provide that level of depth and representation in all of those areas. The collective bargaining agreement that we developed in Baltimore is now serving as a national model, particularly for large urban school systems that recognize a need for a change. Traditionally, we have rewarded teachers based upon seniority and based upon the degrees that they have. And under those plans, you reward the mediocre as well as the high-performing educator. What we've done is to eliminate seniority-based pay increases and pay increases based upon the degrees that the teachers hold, but rather give rewards for teachers based upon their performance, based upon what they bring to the school, what they bring to the school system, and ultimately what they bring to the classroom to help the students achieve. First, I recognize the tremendous importance of what my clients do. They are working directly with students and young adults, trying to help them to achieve the future. My role as an attorney is to help those educators, to help those education institutions so that they can do the important job that they do. And so I meet directly with my clients. They rarely come here. I go to them. I go to the school systems. I meet with them early in the morning, late in the day, and I provide them with the direct attention that they need to maneuver through all of the regulations, the obstacles that are put in their path, to deal with the business of education so they can get to the important job of educating students. If it's a new client, the first thing that I would want to do is discuss their institution. And then we would go into the particular reason for why they called and what we can do as an education and labor practice group in helping them with their immediate problem. Then we would discuss some of their other interests, the areas that they may not be aware of, but which we believe we could help them in. My personal relationship with my clients varies depending upon the needs of the client. Some of my clients call me every day. I have a couple of superintendents who like to send me emails at 5 and 6 o'clock in the morning, knowing that I'm usually up at that time and that I will respond to them shortly thereafter. Other clients, they'll call me once a week or maybe even once or twice a month. It's really client driven. Some of our clients are larger institutions and they have legal issues that arise daily. Other clients are smaller and they have legal issues that arise periodically, and they know that we're there when they need us. We're there 24/7, 365. If I'm not available, one of my partners is. If one of the clients that relies upon one of my partners primarily needs somebody and my partner's not available, then I am. We work very closely together. We keep each other informed of what we're doing so that the ball is never dropped. A client's needs are paramount, and so if one of us is on vacation or with family and can't be disturbed for whatever reason, there's another attorney who's there to provide the client with the advice that they need so that we can deal with the issues as they arise. And sometimes they arise late at night, sometimes they arise on the spur of the moment. There's always a situation that requires immediate attention, and we're able to do that. I do a lot of litigation, both in federal and in state courts, and it's a reality that public school systems in particular deal with litigation on a regular basis. We have claims that are brought by students, parents, and employees, and they have to be dealt with respectfully. They have to be dealt with in a way that we bring the result that we feel that the client needs in as expeditious a manner as possible. So one recent example would be I handled a very sensitive race discrimination case in federal court for one of the metropolitan area school districts. And not only was the school system a defendant, but the principal of a school, an assistant principal, and 2 teachers. And while a school system can expect to be sued, teachers generally do not expect to be sued. And so there was a lot of hand-holding, explaining that this is something that occasionally happens and that we have to deal with it. And so what I did throughout the course of that litigation was to spend time with the clients, explain the process, explain what's going on, why they're not directly involved for some part of it while we're dealing with motions in the federal court, what's to be expected when they have their depositions taken, what's to be expected as we progress forward. And I'm happy to say that after 2 years of litigation in federal court, we achieved a result that was favorable to all of our clients, the institution as well as to the individual employees. And that was gratifying because literally there were tears of joy on behalf of my individual defendants. The school system, again, can expect to be sued on an occasional basis. Individuals, it's a major thing. And so we provide that individual attention, inform them of the process, and when we bring them the result that they're hoping for, share in the happiness of the outcome. I teach at McDaniel College, I teach at Goucher College, I teach at Johns Hopkins University, and I teach at Morgan State University. The courses that I teach are education law courses, and it's important to teach our future education leaders about the legal ramifications of education. And so my classes typically start with a discussion of the First Amendment as it applies to speech, student speech and employee speech, religion, Establishment Clause, Free Exercise Clause. We go into student rights. We go into where the school or school system has the ability to discipline a student, to expel or suspend a student. We talk about searches. We talk about seizures. We talk about employment law, collective bargaining, civil rights, employment discrimination, the authority of management to make management-related employment decisions, and the rights of employees when they're confronted with some of those decisions that they may not like. We discuss about race-based decision-making, desegregation. We start with Plessy versus Ferguson in 1896, go through Brown versus Board of Education in 1954, up through the more recent Supreme Court decisions, and how they apply today when we need to make decisions that affect persons on the basis of race, whether it be student attendance or employment. We discuss litigation and liability issues. What can you be sued for? When can you be liable? When do you have immunity? When will the school system or the college provide you with an attorney free of charge? When are you on your own? These are important issues for educators, and it's usually refreshing for them when they realize that in most cases, as long as they're being sued for something within the scope of their employment, they're being protected by the institution. I think that potential clients should know that I really enjoy what I do. I spend a great deal of time reading and keeping abreast of all of the developments. I'm one of those people who listens to Supreme Court cases on C-SPAN. I enjoy the practice of law, and I particularly enjoy my practice specialty area. So I think that's important for them to know. I think it's also important to know that I put a lot of effort into client work. I am committed to helping them achieve the desired outcome, or if that's not possible, for them to know as soon as possible so that we can regroup and make some changes. Sometimes what clients want is not possible, and they need to know it. I am an attorney who believes strongly in giving bad news when it's necessary. So I'm honest and upfront. I don't hide the truth from my clients. Over the next decade, I expect to see a growth in collective bargaining, which is actually contrary to the national trend. In Maryland, unlike in some other states, Wisconsin, Ohio, Indiana, for example, collective bargaining rights for employees have been strengthened recently through legislation passed by the General Assembly. And we have a new public school labor relations board, which is providing a new vehicle, a new avenue for employee labor groups. And so school systems are going to have to adjust to that change in the law, and we're going to find ourselves spending a lot more time at the bargaining table. I think also that parents and employees are more aware of their rights under the law, and we see them exercising those rights more than they did in the past. And so it's important that we spend more time educating our clients as to the rights of parents, students, and employees, and to help them to avoid turning school-related problems into litigation. We want to help our clients to deal with these issues as they arise so they can deal with them ethically, effectively, proactively, and hopefully resolve them amicably and in good faith. We know that that's not always going to happen, but with the education that we provide to our clients, I think that they're going to be better able to resolve these matters. When they can't, we're there to help defend them in court.